Hi everyone, I'm Amy Odom and I'm here today to talk about the case of Haskell versus McDonough, which was argued before the U.S. Court of Veterans Appeals last week, August 15th, at the University of Buffalo. The case involves a benefit called special monthly compensation. Now, special monthly compensation is an amount of money that VA will pay to veterans every month above and beyond what they get as a result of their combined ratings. So usually to qualify for special monthly compensation, the veteran will be rated totally disabling. And so there's an amount of money that a veteran who is rated 100% gets every month. I believe it's somewhere around $3,000 or $4,000, something like that. But special monthly compensation is even more than that 100%. And there are different levels of special monthly compensation. There's one level, special monthly compensation based on aid and attendance. And that's when a veteran, because of his or her service-connected disabilities, needs additional assistance from another person, whether that is help with eating, help with bathing, or even something like medication management if the veteran's service-connected disabilities renders her unable to manage her own medications and she needs assistance with that. That veteran would be entitled to additional compensation in the form of special monthly compensation. In 1970, Congress created a level of special monthly compensation that is a very high payment. It's about $8,000 a month. And in the business, we refer to that as special monthly compensation at the R2 level. And R2 refers to the subsection of the statute that provides for this special monthly compensation. But a veteran is only entitled to the R2 rate if he or she suffers from severe anatomical or physical disabilities. So we're talking, total blindness plus loss of use or anatomical loss of a limb, things along those lines. So the veteran must have suffered a severe disability, severe physical disability. Need aid and attendance, which we had just discussed, in addition to what's called a higher level of care. And higher level of care are care services that would require some sort of healthcare training. VA's regulation defining healthcare or higher level of care includes things like placement of indwelling catheters, wound care, physical therapy, things that veterans with such severe physical injuries would likely need. And then the last requirement for the R2 rate is that without that higher level of care, the veteran would need hospitalization or some other type of residential institution. Fast forward now to 2010. A lot of veterans are coming home from OIF and OEF with an injury called traumatic brain injury or TBI. And there was a sort of awakening to TBI as a signature injury of those two conflicts. And the type that those veterans need sometimes when they suffer from severe TBIs, they need a lot of assistance with activities of a higher level that involve organization and planning. Sometimes the cognitive residuals of a severe TBI make it such that a veteran has difficulty in his or her own environment, gets lost easily, medication management, these types of things. And those veterans would not qualify for the R2 rate that we just discussed, even if without the aid and assistance of another, they would need hospitalization. And one of the major reasons why veterans with TBI don't qualify for the R2 level is because they don't need higher level of care, as that term has been defined by VA, because the types of care that they need, like the supervision for safety and help with planning and organizing, making sure, that the veteran doesn't get lost and those types of things, are care services that don't require some sort of healthcare training. So in 2010, Congress recognized that these veterans who had severe TBI were not getting the compensation that they deserved, which is the R2 rate, because they couldn't satisfy the higher level of care requirement. So in 2010, Congress created a new provision, a new level of special monthly compensation called Special Monthly Compensation T. And the statute says you qualify for special monthly compensation under the T rate if you have TBI that makes you in need of aid and assistance from another. And without that aid and assistance, you would need hospitalization or some other kind of residential care. What's missing from the statute are the words higher level of care. Nonetheless, VA, in their regulation implementing this statute and describing the requirements for special monthly compensation based on TBI, does require that the veteran show a need for a higher level of care. And remember, a higher level of care, as defined by VA's regulation, means care care involving more physical injuries, like care for disabilities requiring catheters or physical therapy or something like that. It doesn't cover care for disabilities that result in severe cognitive or psychological disabilities. So in Mr. Haskell's case, Mr. Haskell is a Vietnam veteran, and he suffered a severe head injury in combat in Vietnam. And he, as a result, suffered from severe cognitive disabilities, but VA denied special monthly compensation at the T rate, which is equivalent to the R2 rate, because the veteran was unable to show that he needed a higher level of care. So our firm appealed the VA's decision denying the T level of special monthly compensation. And we argued that the VA's regulation requiring the higher level of care, was invalid because it is conflicting with the statute, which does not require a higher level of care. We argued this case before 3 judges on August 15th. Our main pitch was that the statute doesn't require a higher level of care, and VA cannot create that additional extra legal requirement to deny veterans TBI special monthly compensation. VA is continuing to defend their regulation, and they defended it at the oral argument. The rationale that they provided for defending the regulation at the oral argument did not quite line up with the rationale that the VA provided when they proposed the regulation back in 2017, nor what they provided when they filed the briefs in this case. It did not seem that the judges were receiving it very well, but of course we won't know for sure until we see the decision, which we hope to see in the next few months. One hiccup in this case is that, unfortunately, like a lot of cases that go on for a long time, the veteran unfortunately passed away right before oral argument while we were already at court. However, the case should be able to go on because his wife will be able to substitute him at the court. And that means that if we win at court and then he's granted the special monthly compensation at the T rate, VA will have to pay to the veteran's wife everything that they should have paid him during his lifetime. So it's important to keep that in mind too, that nowadays when the veteran dies while his claim is pending, there are substitutes who can substitute the veteran both at the court and the agency. So thanks for tuning in. We hope to receive that decision, like I said, in the next few months, and we will circle back and let you know what the results are then.